permitted to mention item 226.
Item
226, 226. Amit
Item-
Das versus Anand Jashwal. Your lordship will be kind enough to fix any day.
let me see. Let me see how far I can proceed. Please wait.
Since
The file is not here, sir. If the file is not here,
my lord kindly fixes it on Monday to be mentioned. File will be here. I am ensuring.
if the file is here, it will come.
My lord, kindly allows my mentioning.
Yes.
My lord, we had mentioned this matter on Wednesday. It's a contested application. Your lordship said only on one condition, you have to do the matter on Saturday. We said very well. We gave notice to the other side also. But it has not come in the list. The urgency is, it really shouldn't take more than 2 minutes. One sentence added in the written statement after, by way of amendment, after conclusion of the chief. Contrary case, they said that they were not in possession. Now they said they were in possession. Now they are saying not in possession. But your lordship would kindly, my suit is getting stayed. My suit is stayed.
It cannot be taken up.
Not any day, my lord.
This is
My lord,
should
appear today,
Item number one.
my suit is lying still in my.
Contested application motions.
But it is really one sentence in the written statement.
All contested applications are one sentence to
So
sentence.
there is not, my lord, this way or that way, my lord, my suit is lying state, my lord.
All suits are lying state.
My lord,
Mr.
my revisional application, my suit is lying
Mr.
state.
Gupta,
My lord, my revisional application.
maybe Mr. Gupta, in matters where stay has been passed, plaintiff suit will be stayed. That's
I understand, but on my revisional application, my lord,
has to be.
but
Mr.
that is why, my lord, this way or
Mr.
that way,
Gupta,
my lord.
it's not on your revision application or other side's revision application.
Your lordship,
The stay has to be passed considering the effect of the interim impugned order.
I
Give
doubt
the
it.
main proceedings.
But only thing,
So,
this will not take,
be your other side
this
suit.
really will not take any time more than a motion, my lord. It's only one line, my lord, which has been
Mr.
amended,
Gupta,
which is
Mr.
really
Gupta,
changing the nature and character.
The fact is that I have refused bail. If I allow
You allowed it for today, my lord.
I do not have any difficulty.
But your
Please
lordship-
make a choice. I do not have any difficulty. Please
But you
decide among-
allowed it for today, my lord.
Mr. Gupta, yes, I allowed only the motions I have said, upgradation motions, not contested
To me
applications.
specifically, we had said that it's contested. Your lordships are not including any.
Then
Only on one condition, you have to come on.
not contested, it might have missed. Only thing is that I do not have a difficulty to take up contested.
If I take more than 5 minutes, by the time your lordship.
Please hear me. You decide amongst yourself, fix a time limit. I will take up contested applications. I do not have a difficulty. I do not have a difficulty to take up contested from 10:30 onwards also. I do not have a
Day of the
difficulty.
week,
You decide amongst yourselves.
on any day of the week, my
Mr.
lord.
Gupta, if you want, I will dedicate some days for contested applications. I will do that. But motions will get stuck. Then, on condition, you will not pay for upgradation of any motions.
Kindly do not pay. Your lordship has been there in this side. Your
Two
lordship.
things. If you want that the motions is to be given precedence, that is what I am doing. That is why I cannot take up contested
Only humbly
applications.
beseeching, my lord, any one day of the week, kindly do not put us that condition, my lord. Your lordship has spent
What?
many
Has to be,
years.
Mr. Gupta, you will be a contested application. I will be taken up. Then you will say, yes, motions are not taken up. Two things cannot go side by side.
Your lordship will kindly consider, my lord.
Yes, call the.
Only one thing that
Expeditious hearing. Final for expeditious hearing. The probate case is pending since 1995.
Please come on.
but I was not interested in the matters which were mentioned yesterday has been listed today.
Not mentioned yesterday. It was mentioned on Wednesday.
But only thing is that 25
I accepted all the shifts for today. So today it has been published, but the mentioning was on Wednesday, not yesterday.
I think 285 of the list, yesterday's list,
Yes.
execution proceedings, after
You did not mention Mr. Ahmed yesterday. Only the fixed matters who have mentioned, I have said matters from the. I have made two categories. One is
I didn't have knowledge of this. But can you
Wednesday I have accepted on a mentioning. On that day I gave option. So you are not there.
I was
Yes.
not there. Execution,
I can proceed. Let me see. Yes,
but may I mention on Monday?
Wednesday, not Monday.
Item number 1, I am for the petition amendment.
Yes.
My
Any caveat is there?
no, your
No
lordship.
caveat. Yes. What is the matter?
My senior is leading me.
Yes, Mr. Rai. Why do not appeal physically?
There's some problem, personal difficulties.
Yes,
Now, if your lordship takes up the order passed by this honorable on 20th January 2025.
20th of January 2025.
Yes, direction for service, my lord. I do not know.
Mr. Rai, there is a direction for service.
Yes, yes, that is why. I don't know what my learned friend has.
Did not affirm during the course of the day. I will file it.
Sir, today you have taken a resolution.
Milord,
Before I start,
all service is ready and delivery is also completed, Milord.
All right.
Milord.
You have taken a resolution.
may I submit one thing, my lord?
Mr.
The
Rai.
child is suffering from
Yes.
deficiency. He is an autistic child. And the court, in spite of holding there is some difficulty, directed the child to be exposed before the local people. Whether it is permissible. When the
Mr. Rai, what will be done today?
I am not on that. I am not inviting a lordship to take up the matter today. If
Yes.
any precedence is given to this.
Yes,
Otherwise, any precedence, so
precedence it is for today. Precedence is common.
that is why we are trying our luck today, Manad. If not, Manad,
Mr. Rai, today if the other side is there, I can take up. Otherwise, it can.
suddenly, I am not inviting a lordship to call the order today. Any day, so that this is a matter of a child, somebody, disabled child, especially a child. I cannot say this.
At the copy of the civil division application has been served upon the opposite parties. Full stop. However, none appears for the opposite parties. Full stop. In view thereof, the hearing of the civil division application stands adjourned for the day. Yes, next.
Item number 2. Just here for the petition number.
Yes, your other side is here. Mr. Rai. Yes.
Your lordship.
Yes, Mr.
Yes,
Bhatt.
sir. Today, sir, your lordship can fix up tomorrow.
No,
Today, sir.
Mr. Rai, no tomorrow business. These are fixed for today, no tomorrow business.
Your lordship.
Yes.
My section 34 application
Yes.
has been, my lord, returned with an unique finding. It was filed before.
Returned.
Yes. With a unique finding. Now kindly seize this. The impugned order is dated 13th of June 2023.
Yes.
Now, my lord, this was filed. Now, this section 34 was filed before the non-commercial division.
Yes.
Now, the learned judge in the court below says that it should have been filed before the commercial court insofar it's a commercial dispute. And then says that it was not maintainable before that court. And there it's a commercial dispute, should have been filed before the commercial division, and hence it was not maintainable before that court.
Yes.
And I was given liberty to withdraw the application for filing before the proper forum.
Yes.
Now, my lord, two issues. Kindly seize, my lord, the nature of dispute. My lord, may I
According to you, it's not a commercial
It's not
dispute.
a commercial dispute because it arises out of a development agreement. In the development agreement, I will place the clauses, my lord. The owner is supposed to be getting, it was basically residential building that was getting constructed. In terms of the development agreement. My lord,
Maybe a residential.
I'm covered by a Supreme Court judgment which says the language is used and not likely to be used or used in future.
No, that's the Mr. Bordon, that is a different thing altogether. That is, if maybe there are certain types of disputes which relates to the present condition, present user of the building. But if there is a development agreement,
Sure, my lord,
there is a element of profit and other things,
my lord.
commercial
There's
aspect.
a
Even if
difference.
it's for a residential
No,
purpose.
my lord, there's a difference once Millard construes that agreement to be a joint venture agreement or an agreement for construction. So that depends on the Millard construction of the agreement. That's what the Supreme Court says, Millard. Kindly allow me to place the Ambalal Sarabhai ko deto. Millard, kindly seize this, Millard. 2020 volume 15 SCC 585. Look, even if the learned judge in the court below had transferred the suit to the commercial division, even I wouldn't have any problem.
Yes, you have been given liberty
No,
to.
I cannot do that because once, now the section 34, the limitation on the section 34 knows is 90
Is,
90 days.
yes,
Now the point is, once it is returned to me and I go before the commercial court, that time frame, that would not inure to my advantage. I might.
sir, Mr. Bordon, please take an example of a money suit.
Yes.
So money suit filed within the period of limitation, but when this return is being made, that also can be
Yes.
returned.
Yes.
Let us assume pecuniary jurisdiction or whatever. Let us assume it's a pecuniary jurisdiction, lack of pecuniary jurisdiction, and the return is made at a point of time.
When the
when the-
suit otherwise haven't barred.
Yes.
Yes.
So is it the law that when the return is made, you cannot present it because it's time barred?
Kindly see.
Or it's the other way around? Because you have to, when it's returned, you have to file it within that specific time. Then
It's not given. That's not given.
that is
That is also not given. Now that is what preempts my approach to the commercial division. Be that as I've got 2 points. Now kindly seize the impugned order.
is there any provision for direct transfer?
Yes.
Where is that? Commercial Courts Act, देखिए একটা দিন।
15 done. Let's see, 15.
Section
15, my lord. My lord, but that would be my subsequent point, my lord. The first point is, my lord, it's not a commercial dispute.
Section 15 says all suits applications including relating to a has been constituted shall be this is pending.
Pending as on that day.
Pending as on that.
As
So
on
you do not fall within that.
No, I do not. Kindly seize.
Yes. You are on the decision.
Yes.
Yes.
But kindly seize, my lord. Any suit on application including
Paragraph.
that will 3.
Paragraph 3.
3, my lord.
Yes. No, paragraph 3 of
My lord. No, my lord. The judgment I was.
what you are placing.
I'll place the impugned order first then. I'll place the impugned order. My lord, kindly seize.
No, paragraph 3 of what you are placing.
In fact, 15 subsection 3 that was.
Oh, 15. Yes, you can
Well,
place.
that come back. The kindly takes this order for once.
Yes.
Learned advocate, this is an application under section 34 of the Arbitration and Conciliation Act filed by the petitioner for setting aside of the award dated such and such passed by the sole arbitrator in the arbitral reference between the parties. The arbitral reference arose out of a dispute between the parties relating to a development agreement in the nature of joint venture dated 2nd of May 2016. Now, marks this, my lord. The learned court, judge in the court below, enters into a finding that it was nature of a joint venture. Now, my lord, learned lawyer appearing on behalf of the opposite party submitted that the development agreement being in nature of joint venture agreement falls within section 2C 11 of the Commercial Courts Act. He further submitted that the market value of the property, as can be seen from the query issued by ADSR Rajarhat, attached with the said registered development agreement, has been assessed at 70 lakhs. Thus, keeping in view the nature of the agreement as well as the value of the subject matter of the adjudication of this case is subject to the jurisdiction of learned Commercial Court Rajarhat, and on such ground placed for dismissal. Learned lawyer appearing on behalf of the petition, on the other hand, referred to decision of the state of West Bengal versus associated contractors such and such, provisions of the Arbitration and Conciliation Act, and submitted as per section 2(1)(e) of the Act, court means such and such. Then, my lord, he further submitted that as per Civil Courts Act 77, section 19, section 20, District Court Principal Civil Court. Then, my lord, the learned lawyer for the petitioner referred to decision of Telangana, Andhra Pradesh High Court, such and such. Then, my lord, he also referred to a decision of the Honorable Apex Court in Fakir Chand Gulati versus Uppal Agencies Private Limited, in which the difference of joint venture has been discussed by the Honorable Court. This I'll be placing, my lord. Then, my lord, then, my lord, consider submissions. Then the operative portion, my lord. In the context, I find it necessary to refer to a judgment of the Honorable Apex Court in JC Housing Private Limited and others versus such and such. Registered civil appeal number such and such with civil appeal number 6877.
Yes.
I'll just place it for my lord's consideration once. Will you kindly seize this?
Yes, place the impugn order first, I will.
I'll place it.
Yes.
In which the same point which has been raised before this court has been discussed in detail by the Honorable Apex Court with reference to Section 3 of the Act 2015 and Section 2(1) of Option Act 1996, and the judgment cited by the learned lawyer for the petitioner, State of West Bengal versus Associated Contractors, such and such. It has been observed such and such, relating to commercial disputes, so on and so forth. This is basically what the judgment says. Now, the operative portion, page 3. Therefore, considering the aforestated provisions of the Act of 2015 and the objects and reasons for which the Act 2015 had been enacted, and the commercial courts, commercial division and commercial appellate division in the high courts are established for speedy disposal of the commercial disputes, including the arbitration disputes, Section 3 and 10 of the Act of 2015 shall prevail, and all applications or appeals arising out of arbitration under the provisions of the Act of 1996, other than international commercial arbitration, shall be filed in and heard and disposed of by the commercial courts, exercising territorial jurisdiction over such arbitration where such commercial courts have been constituted. Considering the facts and circumstances of the case, and upon perusal of the documents submitted and the discussion aforesaid, keeping in mind that the Honorable Apex Court has put to rest any ambiguity that may have been created in respect of forum for proceedings emanating from commercial disputes of specified value under the Arbitration Act and Commercial Courts Act, by voicing the objective of the enactment of Commercial Courts Act, I am of the opinion that the arbitration arose out of a subject matter which by nature of the agreement is a commercial
If it
dispute.
is, even if it is was the subject matter of arbitration, if it is of the specified value and commercial dispute,
If it's a commercial dispute, I go before the commercial division. If it is not a commercial dispute, I
even if it was a subject matter of arbitration.
yes. So no,
Yes.
no qualms on that. Now, my lord, kindly sees the judgment which was relied upon.
Jesse,
JC, my lord. I'll just take a moment, my lord. JC, my lord. The JC, my lord, was relied upon. Kindly sees, my lord, the head note. Commercial Courts Act 3(1)(a), 3(a), 3(10), 15, 21, Constitution of Commercial Courts, designated commercial courts, judge subordinate to rank of principal civil judge, principal civil court in district, held as jurisdiction to hear all applications or appeals under the Arbitration Conciliation Act, other than those arising out of international commercial arbitration. So, there's no qualms or dispute as regards this, Manoj. But what I say, Manoj, this judgment.
according to you, the dispute is not a commercial dispute.
Yes. So, Manoj, the entire issue before the court was whether the dispute is a commercial dispute or not a commercial dispute. So this judgment does not have any manner of application. This judgment relied upon by learned judge in the court below. Now, kindly sees what is the dispute. The dispute is a development agreement which appears at page 19. Kindly sees, I'll place the relevant sections.
Mr. Bordhan, it was Mr. Rai's objection
Yes.
on the basis of which this
Yes.
was done.
I,
Show me the objection
yes,
first.
the objection, is at page 158.
Which volume?
Second volume. Now, volumes. So we are not in any fault anymore.
You are at fault.
We are at fault.
Making 2, 3, 4 volumes of a civil division application.
Can't help it. Otherwise, we are hauled up for guilty of suppression.
Suppression.
Yes, we are not disclosing documents.
All right.
Not
Yes.
doing with clear hands.
Yes.
Kindly
What
see,
is the effective objection?
Objection is commercial dispute.
No, show me what is.
Paragraph 1, last 4 lines.
Paragraph 1 is.
Last 4 lines, being in the nature of joint venture agreement is something what they say, which is echoed by the learned judge in the court below. Thereafter,
Development agreement being in the nature of joint venture agreement.
yes. Then kindly sees said development agreement being nature of joint venture agreement falls within 2C11 of the Commercial Courts Act, measured as commercial dispute. This is the sum and substance of their objection, Manoj.
Yes.
And then said 70 lakhs valuation and therefore commercial dispute above a
70 lakhs market value of the property.
Yes. So above the specified value. So commercial dispute above specified value, Manoj, before the commercial division.
So valuation is not in dispute.
No.
So, but the question is whether
Whether
it's a commercial dispute or not.
So, The application seeks rejection of my application on the point of jurisdiction.
Where is your objection to this? Objection to the objection.
My objection to the objection, since I believe this was one on
This is
point
not
of
an
law,
objection. This is an application for dismissal.
I don't think we preferred any.
Oh, you have not filed any.
No, it's point of law.
This is on the application on the ground of maintainability.
Yes. So point of law.
Objection as to the maintainability.
Because I don't see, any reference to any objection in the impugned order, So I believe probably it had not been filed.
Yes.
No, so the entire issue now hinges on whether dispute is of a commercial nature or not. Kindly takes the development agreement, which is the bone of contention. The development agreement starts at page 19. Certain clauses I'll be placing, and then I'll take
19.
19. This is volume 1. The first clause I'll be referring to, at page 21, sees the names of the landowners and the name of the developer.
Mr. Bordon, give me 1 minute.
Sure,
According to you, it's not a joint venture agreement. Mr. Bordon, does it not fall within 2C6?
Precisely, There's where the language comes exclusively.
No, 6.
Yes.
6 does not say exclusively.
Construction and infrastructure contracts,
Yes.
including tenders.
Yes.
Infrastructure contracts,
And construction and
this is in the
not only construction with regard to infrastructure.
no,
construction.
kindly, if this construction and infrastructure contracts, if this phrase or this clause takes into account the construction or development agreements, then the issue of joint venture agreements or the transactions thereafter relating to immovable property, that would not have come into force. If what is falling from my lord, if 6 has to be construed in that fashion, then 7 and 11 would lose its significance. Then 7 would lose its significance. Construction and infrastructure
According
contracts.
to you,
Yes,
that apart from that infrastructure contracts, if it relates to immovable property,
that comes in 6.
that comes into 7.
Sorry, 7.
That falls within 7.
7.
And any joint venture agreement, maybe with regard to construction or otherwise,
Yes, would come under 11.
Would come under 11. So your interpretation is that if any sort of agreement, including construction agreement,
On a piece of
respect
land,
a property
on a property,
exclusively used for trade and commerce, that would
that's
only,
the Supreme Court holds. I'll show that,
yes.
So, even I say this, even this issue which my lord is now posed with, this issue has not even been gone into by the learned judge in the court below. Had he gone into this issue and decided it, I would have still understood. But he's not gone into that.
No, the learned judge has stated that it's a joint venture agreement.
Yes, but whether my agreement also falls within 7 is something that is not even gone into. So that he ought to have gone into, that is the error of jurisdiction. And why I say this, my lord, because even the learned judge in the court below records that the reliance was placed on the judgment of Fakir Chand Gulati, my lord, which for the first time, my lord, lays down as to what a joint venture agreement would be, or whether, my lord, an agreement between the landowners and the developer would be construed as a joint venture agreement. The judgment that years. My lord, may I place the, my lord, the development agreement, my lord? My lord, place the development, the
Yes,
clauses,
yes.
and then I'll take, my lord. So,
Take page 19.
my lord, kindly see page 19. So that starts, my lord. Page 20, it's from page, my lord, 19, it starts. The name of the principal, my lord, 3.1. At page 21 are the names of the others who are the landowners, my lord. Then, my lord, the name of the petitioner who happens to be, my lord, the developer. Now, my lord, if my lord kindly comes to page 26 at clause 6,
Yes.
desire of development of the land and acceptance, that said Joyita Sahu, Otanu Mondol, Somnath Mondol, and Orno Mondol landowners herein express the desire to develop the aforesaid plot of land more fully described in the first schedule hereunder, written by constructing a multi-story building thereon, and the present developer accepted the said proposal, and the present landowners have decided to enter into the present development agreement with the developer herein for the land mentioned above and explicitly in the first schedule hereinafter written. Then, my lord, registered power of attorney, my lord, then, my lord, kindly comes to, my lord, page 27.
Yes.
Sees the landowner's allocation, my lord.
Developers. So it's
No, my lord,
clearly a-
no, my lord, kindly sees. The owners is and shall be fully and completely entitled to 40% share of the total constructed area of the proposed new
that's in a-
residential
that-
building.
that is in a development agreement. Owner have an allocation and the
Yes.
developer has an
Okay, my lord, why I need to place these clauses is because, my lord, of the judgment of Fakir Chand Gulati, my lord. Then, my lord, kindly sees, my lord, page 29, para 10.
developer's rights.
Yes, my lord, kindly sees right of construction at 10.2 and 10.3, my lord. Landowners hereby grant permission of an exclusive right to developer. Then total construction work is to be carried on with their own costs and expenses of the developer. Then, my lord, kindly sees page 30, para 12, my lord. And, my lord, also see, my lord, 10.5 profit and loss. So profit and loss restricted to developer's allocation. Then, my lord, exclusive power of dealings of the landowners, kindly sees 12.1 at page 30. They have the right to transfer their allocation.
Yes.
Then, my lord, kindly sees page my lord, page 34, para 14, my lord. The developer shall at their own cost construct and complete the proposed building, so that at the cost of the developer. Then, my lord, page, that's page 30. Then, my lord, kindly sees the arbitration clause is, my lord,
That is no dispute because it was.
so this is the nature, my lord.
Yes.
Now, my lord, we say that this is not a joint venture agreement. Why, my lord? Now kindly takes up the judgment of Fakir Chand Gulati, my lord, which I have handed over to you, my lord. 2008, volume 10, SCC, page 345.
Yes.
My lord, the relevant paragraphs would be, my lord, paragraph 20. Page 359, my lord.
Yes.
Kindly sees there is no dispute or doubt about the complaint under the act will be maintainable in the following circumstances. Well, two issues were, my lord, framed, and then, my lord, but we are concerned with the third hybrid category, which is popularly called as joint venture agreements or development agreements or collaboration agreements between a landowner and a builder. Then, my lord, kindly sees paragraph 25. An illustration of joint venture may be of some assistance. An agreement between the owner of a land and the builder for construction of apartments and sale of those apartments as to the share of the profits in a particular ratio may be a joint venture. If the agreement discloses an intent that both parties shall exercise joint control over the construction development and be accountable to each other for the respective acts with reference to the project. Now, this is the reason, my lord, why I placed those clauses of that agreement. Then, my lord, we may now notice the various terms in the agreement between the appellant and the first respondent will militate against the same being a joint venture. Firstly, there's a categorical statement in para 24 that the agreement shall not be deemed to constitute a partnership between the owner and the building. The landowner is specifically excluded from the management and is barred from interfering with the construction in any manner. This is precisely the case that we run, my lord. Builder shall have the exclusive right to appoint the architects, contractors, and subcontractors for the construction. This is precisely, my lord, what we do. The builder is entitled to sell its share of the building as it
Sell its share of the building.
Yes, its share. That means developer's share. So in our case also, the developer has its right to sell his share without any reference to the landowner. Then, my lord, most importantly, the builder alone is responsible to pay penalties. No community of interest or common joint control in the management nor sharing of profits and losses. The landowner has no control or participation in the management of the venture. The requirement of each joint venture being the principal as well as the agent of the other party is also significantly absent. We are therefore of the view that such an agreement is not a joint venture as understood in law. Similar to where a development agreement envisages these clauses that the developer, I'm sorry,
Yes, yes.
where the developer envisages these clauses where the developer is the person who is alone responsible with the construction, then it is not a joint venture agreement.
It has been clarified in paragraph 28.
Kindly, my lord. The basic purpose of the agreement is the construction of a house or an apartment in accordance with the specifications by the building for the owner. The consideration for such construction being the transfer of undivided share in land to the builder and grant of permission to the builder to construct 2 floors. Such agreement, whether called the collaboration agreement or a joint venture agreement, is not, however, a joint venture.
So nomenclature is not relevant. What is the substance?
Yes. So
even if you style it as a joint venture.
yes, what I say, my lord, having regard to the clauses in my development agreement, that cannot be construed to be a joint venture agreement. That cannot be construed to be a joint venture agreement because of the clauses which I just placed. That the developer is retaining unto himself all the facets of construction. Kindly, takes it once more, kindly takes,
So, but the
34.
yes, learned judge proceeded on the basis it's a joint
venture. He did not proceed, my lord. He did not proceed to see as to whether, my lord, my agreement falls within 2C7. That is the error of jurisdiction, my lord. And I will show, my lord, that the Supreme Court has also said that having regard to the language used in 2C7, the property has to be used.
The learned trial judge proceeded on the basis that it is 2C11.
Yes, joint venture.
Yes, 2C11.
Yes, which I say and I show that it's not a joint venture agreement.
But these aspects were also not considered.
Yes, if my lord remands it, fine enough. If my lord remands it, fine enough. I will not stand in the way.
Mr. Rai, what do you say? Because perhaps prima facie the learned judge proceeded on the basis that it's a joint venture agreement. So it's a commercial dispute and valuation Mr. Bordon is not disputing that
So
it
where
is
is the
30, but the question remains that the perhaps the court proceeded on the basis that it's a joint venture agreement without in effect saying anything with regard to the nature of the agreement in question. So let it be remanded back, let the learned judge reconsider it, because nothing on that only merely because you are stated to be a joint venture, it has been said that it's of specified value and commercial dispute. What do you say to this?
Only one thing, my lord. Today, my lord is considering whether the nature of the agreement is a contract, commercial in nature or not. This is some and substance.
Yes.
Now, my lord, Mr. Bordon argued regarding, my lord, can you consider 2C6?
This is what has fallen from your lordship, and Mr. Roy has
No,
taken it up.
Mr. Roy, where is that finding? That
I
finding?
am on
Where is that finding? Mr. Roy, show me the finding of the learned judge,
2.6.
which under which clause of section?
I'm not on 2.6, so the conclusion. I am on the conclusion. Find
Yes.
this. I'm on the conclusion.
No, Mr. Roy, conclusion has to be based on some reasons. Show me.
Yes, that is a minor can supply the reason. If minor number of cases, minor supplies the reason, minor, the conclusion is correct. Minor can supply the reasons.
That I
Why
will.
did not-
Show me-
Inadequacy of reasons and no reasons are two different things.
Yes, Mr. Roy.
Now, what is the joint venture agreement which I will cite in? Minor, can you consider what is 2.6? What is 2.6? 2C6. Construction and infrastructure contracts. My
Yes.
learned friend was arguing that this is in respect of the construction, which does not fall within the purview of joint venture agreement. Pause for a moment, I'll satisfy your lordship. Construction and infrastructure contract for the purpose of commercial use comes within the purview of commercial contracts. If a construction infrastructure contract is given for the exclusively for the owners, users, then it does not come within the purview of commercial contract. Am I clear to your lordship? When a person intended to build or construct his own house or own apartment and granted contract to somebody else, then that does not come within the purview of commercial contract. But when there is this contract is given for the purpose of making construction, from where the persons are making profit, here your lordship, there is no investment on the part of the landowner.
Yes.
There is no investment. So therefore, my lord, the landowner is getting something by allowing the contractor to build the construction and making such profit. It comes with because the agreement embodied that commercial nature. It is in a commercial nature.
Where is that finding that it falls within 2C?
That is what precisely I am reading. If your lordship on the face of it, it comes within the purview of commercial.
Yes.
Yes, Mr. Bondon is excited.
As usual.
Yes.
Yes. What is the reason you have done?
Yes.
Now, second is joint venture.
Yes.
If your lordship can consider the joint venture. So therefore, my lord, as of before I skipping that question, today the agreement which is before your lordship, whether it is commercial nature or not. If it appears to your lordship it is a commercial nature, irrespective of fact whether the findings is based on some other fact or not, then my lord can decide the same. Here is the agreement which my learned friend is submitting. This is it is nomenclature is joint venture agreement, but actually it is not a joint venture agreement in view of the judgment reported in 2010 STC. Now,
Yes.
my lord, what is the share?
Yes.
Yes. I'm to some extent handicapped today.
Yes.
27, page 27. 8
27.
Yes. Yes. Page 27.
Your lordship will find the clauses.
Yes.
It is the clause that it is joint venture agreement is something where there is no contribution of the parties for the purpose of making construction. Am I clear to your lordship? Here,
Yes.
my lord, the landowner is giving the land.
Yes.
It is his contribution.
Yes.
And the contractor will make construction, it is his liability.
Yes.
He will get this application. This is out of the investment he has done by donating the land. He'll get the constructed value of 40% of the total construction. Therefore, my lord, it is the involvement of both the parties in this project. It cannot be said that it is given in such a manner that he has loses his control. This 40% construction is given to the landlord where he has invested by way of putting the land into this construction project. Therefore, my lord, as on this day, if you logically consider that way, also the construction or this development agreement is also in a other way is a joint venture agreement when both the parties are interested in the project itself, and the investment is common. Whether monetary investment and in lieu of immovable by way of immovable property. My lord, no partner in a partnership act, the partners can invest in various ways.
Yes.
So therefore, my lord, here is the 60-40 ratio which has been mentioned. For what reason I put this question to myself? Why is it 60-40? Because this is the restricted in the manner how we have investment in lieu of that what we will get. That if you donate the land or you put the land in this construction or business, then you will get the 40% out of the total construction or the construction value. And as I have invested the money, then I am entitled to get 60% of the construction value.
Yes.
And if you are not sure, can you consider how this development agreement, who is applying for the other essential things, the trade license, plan, and other necessary documents are issued in the name of the person who have invested or who have given the land in question. But given the power of identity to that person, that portion, my lord, Mr. Bhartapur may enlighten your lordship, who will apply for this?
I will.
Yes. Anything more? Mr. Bogdan, why did you cite this Ambalal Saravai?
Yes, in Ambala Sarabhai, my lord, what was being considered was this 2C7.
Yes.
So there, my lord, it holds, kindly sees the relevant paragraphs to the paragraphs 11 onwards.
No, did it relate to this construction agreement? No.
Yes, development.
Here,
Yes,
show me that.
kindly sees. This is paragraph, this would be paragraph 11.
Paragraph.
Page 592. I did not go into this because I thought my lord would be in the mode of remanding it to consider this aspect. But if my lord considers the aspect out here, but I'm ready with this as well. Kindly see paragraph 11. On a plain reading, my lord sees next to placentum G. On the other hand, learned senior advocate for respondents has relied upon the decision of division bench of Gujarat High Court in such and such, wherein a detailed consideration has been made and the conclusion reached therein by taking note of an early decision is that on the plain reading of 21C of this Commercial Courts Act, the expression used must mean actually used or being used. It is further explained that if the intention of legislature was to expand the scope in that case, the phraseology would be likely to be used or to be used.
Yes.
Then Mulot kindly sees paragraph 33 has been quoted from the Gujarat High Court judgment.
Yes.
Kindly sees Mulot next to placentum D. Considering 2C7, commercial dispute means a dispute arising out of agreements relating to immovable property used exclusively in trade and commerce. Now, Mulot, the word exclusively has some significance. That is what the Supreme Court goes on to say.
Yes.
Exclusively means it has to be exclusively used for trade and commerce. Even if a particular portion or a particular part of the contract envisages an intention that is not to be used in trade and commerce, even then such sort of agreements.
No, show me that this in this the dispute was with regard to a development agreement.
I'll just show you. Kindly see.
Where is that?
I'll just take a moment of one moment of my knowledge. Let's kindly sees paragraph 3. It was the nature of an agreement for sale.
Yes.
Kindly see.
Not a
No, relating to land. relating to land.
Yes, agreement for sale relating to land, not a development.
No. That's an agreement.
That is why I asked you that,
But-
show me that.
My
this is
lord,
the-
now the subject correction. My lord, a development agreement is now today stamped as if as it's an agreement for sale, insofar as, my lord, the portions which the developer gets is basically in lieu of something that is doing on the property. That's what Fakichan Kurati holds. So, my lord, that is also in the nature of an agreement for sale, and it is stamped as such. That is the reason we draw an analogy between, my lord, a development agreement and an agreement for sale.
All right.
And Mulot kindly sees, so Mulot, then paragraph 5th, then Justice Bhanumati's Mulot observations at para 37, 39 and 41.
So this is exclusively that has been
Yes.
explained.
So if Mulot subject
And present user, not
Yes.
future
Yes.
use.
So if as on this day, Mulot, this is a residential complex which is being Mulot constructed. So it cannot be said that it is being exclusively used for trade and commerce. That's my second issue. My first issue still remains that in the nature of this agreement, this is not a joint venture agreement. And the learned judge in the court below proceeded only on the aspect of joint venture. In fact, that was the only case which Mr. Rai's client was running in the court below. It was not Mr. Rai's client's case that it is covered under 6. That is a cue which he has taken from one at the bar. I appreciate that. But that was not the case that he was running in the court below. So the learned judge, if he had to decide, if he had the 2-6 as well, that was not before the learned judge. In fact, the order shows that he proceeded only on the basis that's the joint venture agreement, nothing less, nothing more. And my issue was, it was not a commercial dispute in view of 2C7. That aspect had not been gone into. But that is the error of jurisdiction. So, my lord, decides it here and now. I am ready.
This application under Article 227 of the Constitution of India is at the instance of an applicant under Section 34.
Yes, my lord.
Is at the instance of an applicant under Section 34 of the Arbitration and Conciliation Act 1996.
Okay, allow me to join other court.
Yes.
Other court for joining.
You are sitting in the chamber.
Going to other
How is
Join to join. That did my lord.
Yes. Applicant under Section 34 of the Arbitration and Conciliation Act 1996 and is directed against an order dated June 13, 2023, passed by the Learned Additional District Judge, First Track, 5th Court, Barasat District, 24 Parganas North, in miscellaneous case number 24 of 2022, within bracket ARB. Eta capital, RB, it is small. By the order impugned, paragraph 3, by the order impugned, the said miscellaneous case was held to be not maintainable as the arbitration arose out of was held to be not maintainable before that court, and it was held that it was further held that the same ought to have been filed before the Learned Commercial Court. First of paragraph. Where is the arbitral award?
The arbitral award is at page 113.
Judgment form. 113.
Volume 1.
Where is the dispute which was referred to?
Dispute, Millard, which was referred to.
Please find it out that the parties to this, the petitioner and the opposite parties hearing
Relief তো আছে তো paragraph.
entered into a development agreement
The
for-
prayers are at page 125.
for the purpose of developing where is the schedule of the property,
Schedule
which
of the
was the subject matter of
matter.
development.
Well, kindly give me
Uh,
it would be page 42.
Page
42.
কি বললাম for an amalgamated plot of land measuring 4.50 decimals more or less of Danga land in RS tag number 1302 and also land measuring about 26 decimals more or less of Bagan land in RS tag number 1303 in total. There are several plots.
Several plots.
কি বললাম entered into a development agreement in respect of several plots of land which has been specifically mentioned in the first schedule of the development agreement dated
The agreement is dated 2nd May 2016.
2nd of May 2016.
2016.
2016. Yes, now where is the dispute?
The disputes, my lord, are at paragraph of this page, my lord, 125. These were the, my lord, the reliefs claimed.
A dispute cropped up between the parties with regard to the development agreement, and such a dispute was referred to an arbitration. Section 11
No.
was referred to an arbitration by the
Appointment. Unilateral appointment.
was referred to an arbitration before the sole arbitrator. First up.
By the opposite parties, my lord.
By the opposite parties hearing. First up, the parties participated in such.
No, I did not participate.
You did, Now you are filing the affidavit of service.
It's appearing.
Affidavit of
Why
service,
keep it with us?
affidavit of
I got
service.
our files.
Please.
I'm so grateful. Malad, so grateful.
Thank you. Yes,
File
next.
number 3.
Please, my lords, I'm appearing online. I beg to appear online, my lords.
Yes.
My lord, this is an order passed by the Honorable Commercial Court Rajarhat, by virtue of which my application under 710 was dismissed on the ground that it is the plaintiff only who can file an application under 710. Without going into the merits, just on the aspect that the defendant does not have a right to file 710 application. My lord's impugned order is at page 35, annexure A.
The ground of your return.
My lords, the ground of my return on demurrer, my lords, my entire grounds was on the basis of demurrer that in the suit, neither the defendant resides within the jurisdiction nor there is a cause of action. It is a patent infringement suit, my lords, and that's the reason section 20 determines the jurisdiction. My lords, may I even have a look of the suit, my lords? My lords, suit is at page 41, my lords, starts from page 41. I can quote, my lords, the relevant paragraphs also, which will evidently show that this Commercial Court Rajarhat does not have the jurisdiction, my lords. My lords, page 42 is a memo of parties, my lords. May I, my lords?
Please give me a minute.
Please.
The learned advocate appearing for the petitioner may be justified in arguing that the defendant also has the right to apply under Order 7, Rule 10 of the Code of Civil Procedure. First up, paragraph, petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file an affidavit of service on the next date. There shall be an order of stay of all further proceedings in
My lords, TS3 of 2022.
22 within bracket CC pending before the learned judge, Commercial Court at Rajarhat, District 24, Parganas North, till the end of the month of December 2025 or until further orders, whichever is earlier. Contested application after 12 weeks. Yes, next.
File number 4.
But I appear for the condition.
Yes. Yes, where is the opposite party?
My lord, I have half copy, my lord.
Today?
My lord, only predicament is, my lord, kindly fixed because they are direct court below, my lord. My lord, is not, my lord, reluctant to, my lord, act on the matter. Lordship kindly
Separate
appreciate.
occasions, you took time.
That was, my lord, due to my eye surgery, my lord, cataract surgery. So kindly fix it, otherwise, my lord, whole
Thing will be,
will be rendered infructuous, my lord. A vital question
nothing
is
will happen.
involved.
My
lord, kindly
learned
appreciate
advocate
this.
for the petitioner is cannot fix because other matters are fixed on other days. It's difficult for me to fix a
Garnet
date
court
now.
will is reluctant not to give any further adjournment. That is the whole difficulty, my lord.
Yes, yes.
Plaintiff in a suit for eviction. Mulad 7172 filed by the defendant on 19th of December 2022. Mulad that is pending till date.
This application under Article 227 of the Constitution of
Number 6. 6, my lord, I am for the petitioner.
yes.
My lord, in this matter, my lord, after 5 years, 5 years after completion of the PW and after completion of DW, and my lord, after completion of argument, when the matter is posted for judgment, my lord, the prayer of the petitioner for my lord, examination of another witness has been allowed. This is precisely is the my lord, impugned order. গেল কোথায় আমারটা? And also, we have also raised that point in our written notes of argument that these witnesses has not been examined. Thereafter, my lord, the prayer has been allowed to my lord, cover up the locuna.
Yes, attesting witnesses of the will.
My lord, we have raised that point that these witnesses has not been examined. And my lord, PW was closed. PW was closed on 2019. And my lord, thereafter they have my lord, submitted their written notes of argument. Thereafter, my lord, after the order of this honorable court, DW was allowed. My lord, we have made our my lord, witnesses. And thereafter, my lord, we have submitted our written notes of argument saying that these witnesses are not been examined. Thereafter, the court allowed that.
Attesting witnesses are necessary for the purpose of proving the will.
Yes, my lord, but to
So
cover
we be entitled to cross-examine
yes,
them.
my lord, but that is to cover up the locuna. My lord, my argument will go.
Nothing will go.
But because-
Why your argument will go? We cross-examine the attesting witnesses.
my lord, even if my lord, but the principle of law is that it is not to be covered up the locuna. Yes,
Show me.
And-
Show me the decisions.
yes, my lord, and my lord,
Show me the decisions, sir.
my lord, I will show, my lord.
Show.
My lord, this is the my lord, principles of law that locuna will not be covered.
Show me what are the decisions
My lord,
we are in your support.
my lord, if your lordship kindly sees, my lord, our written notes of argument, we have made that point, my lord. This is our written notes of argument.
They accept that. Show me that it cannot be allowed at this stage.
Malas, after malas, if it is posted for judgment, my lord.
If it is posted for judgment, show me by which order it was
Yes.
posted for judgment.
Yes, my lord.
When?
Grateful for your lordship.
Yes.
Malas, kindly give me a minute. Yes. This is the order, my lord. 5/4/2024 is for delivery of judgment. If your lordship kindly see. 2024 is for my lord delivery of judgment. And thereafter, my lords, we have submitted our written notes of argument.
Thereafter, the defendants are permitted to adduce evidence.
No, my lords. Before that.
Yes.
Kindly seize that order, my lord.
Yes.
We have, my lord, already cross-examined. In my lords, we have completed on, my lords, 31/1/2024. We have completed our DW. And thereafter, my lords, written notes of argument was submitted. And thereafter, 5/4/2024 was, my lord, fixed for delivery of judgment. And on that date, Malas, they have filed an application to take steps. Thereafter, Malas, they have filed this application in Malas June.
You are the objector.
Yes, my lord.
Yes.
The only object.
Any decision you want to cite?
Malas, I will cite if your lordship kindly gives me.
Is future tense nothing. Today are fixed.
And Malas, the order which I have referred to in the Malas judgment,
Yes.
that itself said if it is posted for judgment, that cannot be allowed.
Which order?
We can produce that Malas judgment.
Show me.
Malas, if you see, if your lordship sees the impugned order, it only says hearing of argument is not a distinct stage, and Malas, in that argument, it has been Malas specifically written that if it is posted for judgment, then cannot be allowed. Hearing of argument is different thing. If it is of hearing of argument, then Malas, we can consider it. But Malas, it is already been posted for delivery of judgment.
Have you got 2011 volume 11 Supreme Court cases? You have not brought that.
Yeah. No.
Yes.
May I come back with the judgment, Malas?
This application under Article 227 of the Constitution of India.
be put to such terms. Whereas the Supreme Court held that it should be put to such terms. Whereas the London High Court did not follow that. It has not been subject to any condition.
Yes, next. Oh, I'm coming after 5 days.
Matter number 7, my lord. I am appearing for the petitioner, my lord. I am led by Mr. Anito Chatterjee in this matter. Tell your lordship, my lord,
Lord, I have a very preliminary point for your lordship's kind consideration.
Come physically.
Mr. Ramajit,
I had some personal problems today, my lord. I was not well. But and it's not a, my lord. After I came back yesterday, my lord, it was very, very difficult for me. Otherwise, I had every plan to go, my lord, today. The problem, my lord, in this matter is I feel that the suit which is filed, my lord, before the
Other parties also.
my lord, we have served, my lord, at
Chatterjee,
least
how-
on, my lord, 2 occasions in regular courts, my lord. These have been taken up for want of this.
Maybe, but today it cannot be taken up, Mr. Chatterjee.
any day, my lord fixes whenever your lordship pleases.
Tuesday, my lord, kindly keeps it on, my lord.
Today I cannot fix, others because other matters are fixed on other
Sorry,
days.
my lord, I shall mention Monday, my lord, for fixing this matter.
The
My lord, may I pray for this? May I pray for this? My lord, it's like this, my lord, that they are trying to enjoy an interim order where the suit itself is not maintained. My lord, what happens is, just give me a second, my lord,
Chatterjee, today it cannot be taken.
I know, my lord, I know, but I'm trying to convince your lordship, my lord, that I'm in a little bit of a soup here. The problem is, in my property, inside my property, I am trying to, my lord, make repairs with respect to a room which is in a dilapidated condition. They are saying, my lord, that I have no right. They are not asserting a right of their own.
Chatterjee, I will consider today.
Very well. My lord, may I pray for this, my lord, that your lordship fixes any day, my lord, next week?
It cannot be fixed up. Appears for the
Monday.
petitioner, none appears for the opposite party. So for the ends of justice, the hearing of the civil division application stands adjourned for the day. Yes, next.
My lord, the service may be kept on record since an order has been passed. Let the affidavit of service.
Evidence service filed in court today is
My
taken.
lord, will it be my lord's pleasure, my lord, to include it somewhere, my lord, so that it can be taken up?
These matters, it's difficult, Mr. Chatterjee, because I have fixed dates thereafter. So it's difficult
So,
to.
my lord, may I ask this question to myself, my lord, where does this now go, my lord? Then, if I have a chance of getting it heard,
Where it were previously, before today.
then, my lord, again the entire process of, my lord, then the point of coming before your lordship on 2nd August becomes, my lord, otious.
Huh? No. Adjourn for the day. Yes, next.
Item number 8.
There is no caveat.
Yes.
No, my lord, I am.
Yes.
No, my lord, I am the plaintiff in a suit for declaration and injunction.
Yes.
My lord, my plain case is that, my lord, I have a, my lord, shop in the Howrah railway station complex, in which, my lord, I have a valid agreement with the railway authorities, which is valid till August 2026. Now, my lord, in front of my shop room, my lord, my plain case is that the railway authorities were stacking mud, which was, my lord, causing hindrance to my egress and ingress. But I filed a suit. My lord, kindly comes to paragraph.
Impugned order.
My lord, impugned order is order 39, rule 7 rejected. Because, my lord, thereafter.
Give me a minute. Give me a minute.
KMDA 1.
Yes, where is the plain?
My lord, kindly comes to, my lord, page, my lord, annexure page 20.
Yes.
My lord, kindly comes to paragraph 14 of the plate. Paragraph 12 of the plate. My lord, this was my cause of action for filing the suit. My lord, it is not at all, my lord, my plain case is not encroachment. But thereafter, what they do is, but I was enjoying an order of injunction.
Paragraph,
But paragraph 12, that was my plain case. But my cause of action for filing the suit. But in which my specific case was, they were attempting.
where is your application for local inspection?
But it kindly comes to application for local inspection, page 125. But I have amended my plaint. Thereafter, my lord, I filed the application for local inspection, saying that after the order of injunction, they have constructed the garden my lord, shop. Kindly comes to page 125. Paragraph 3. And page 127 is the schedule.
Yes. Yes, Mr. Talukdar. You are appearing.
My lord, no copy has been served. If your lordship desires, my lord, the suit is at the, I am told, my lord, at the peremptory hearing.
Yes, that may be, but there is an application for local inspection.
Local
The
inspection.
allegation is that in front of his property, some construction has been made.
My lord, subject
So-
to correction, my lord, the suit itself was filed, my lord, alleging encroachment.
No,
No,
the plain
Not
case is not the
encroachment.
encroachment.
not encroachment. That's not the plain case.
And at this stage, when it is at the
I'm
peremptory.
directing him to serve because you have not lodged the caveat. Ashun. By the order.
Date for proceeding with the suit.
Yes, what is the date? Proceeding with the suit, what?
আরে অর্ডারটা বের করো। কিছু তো ওরা চেম্বারে করিস
It is for, with the intention to collect evidence and
But it is not with the intention to collect evidence.
Yes, call the
But
next.
kindly
matter.
grants me a stay.
Not stay.
But at least stay of operation of the order impugned.
Sir, local inspection rejected, what stay?
Now, my lord, kindly
That
stays
is what
the
you have
suit there.
paid.
But my lord,
That you have also not paid for,
but I paid for.
maybe.
But kindly, my lord, cease my prayer in the suit.
Yes, nothing will happen. Nothing will happen in the meantime.
But kindly says I am praying for adjudicating operation of stay of all further proceedings as well as stay of operation of the suit.
Yes, yes, nothing will happen. Let it proceed.
But
Let it proceed to some extent. Yes. Next. Who is appearing? None appears for the petitioner at the time of call. No.
This matter is coming for the first time,
Yes.
No caveat in this matter.
No caveat. Yes. What is the impugned order?
The entire execution proceedings, I have challenged because the consumer forum, do not have any jurisdiction to entertain any matter with regard to cooperative societies, The person concerned, obtained a loan from the cooperative bank. He defaulted. Account was termed as an NPA. Thereafter, proceeding under section 139 was initiated. Certificate proceeding under Bengal Public Demand Recovery Act.
Did you raise the point of mentality before the state commission?
The state before the district commission, the matter was filed during the COVID. It was heard ex parte, award was passed. But after passing of the award, after 4 or 5 months, it was served upon us. We during the COVID only, we filed an appeal. It was held time barred. It was dismissed. A second appeal was preferred. It was also dismissed. In the meanwhile, the execution proceeding is going on. The West Bengal
In the execution proceedings, did you raise the issue of mentality?
we have raised the issue of we have filed a stay application during the pendency of the appeal before the state commission, Since the state commission's proceeding before the state commission, was dismissed, it was remanded back, Today, there is a warrant of arrest application is pending, which is sought to be taken up before.
No. That is, show me that you have taken this point of jurisdiction before the.
In the appeal proceeding, we have taken
No,
the
in
point
the
of
execution.
jurisdiction.
Appeal proceedings have been dismissed up to the second appeal
It
stage.
has been dismissed.
So now in the execution, show me that you have raised the point of jurisdiction.
We have preferred an application for stay, which was
The application,
regard to-
Robia, that you have raised the issue that it's not maintainable. You have prayed for dismissal of this execution application on the ground that the order award is a nullity. Nothing of that sort.
No,
I can give you liberty. You can take out an appropriate application with regard to that.
in the meantime,
In the meantime, no, nothing.
because,
Item number 11, Your Lordship, this is the revisional application. I was a defendant number 2, Your Lordship, before the trial court. This is against an order of dismissal of my Order 7, Rule 11.
There is no other side?
Your Lordship is pleased to admit the civil revision.
Yes.
And we were directed to serve. Kindly, I would
It
request.
cannot be taken up today.
I understand, Your Lordship. So I was just requesting, because Your Lordship had directed to serve on them. We had filed an affidavit and we are filing an affidavit in service. Kindly
Don't
take it
file
in
it
record.
today. Not today.
Another request is, Your Lordship, that we also mailed the other side to appear today, because since this is an exceptional day, there was no response from their side.
Today cannot.
Informally, I would just say that we were informed that they might not appear in the matter.
Today it cannot be done.
And my only request is, if this can get some special attention of this matter of Your Lordship.
I'm refusing others.
I have realized in court.
The learned advocate
7
for
only.
the petitioner is present.
Appearing for the husband opposite party. They have filed a section 24 application before Your Lordship, and showing the section 24 application, they are constantly taking time before the learned court below.
This is a section 24.
Lordship.
Section 24, I do not-
27 from section 24.
Oh. Petitioner is not present, none appears.
Item number 13.
But I appear for the petitioner, but I have served my lord the opposite parties. But execution proceedings pending before the district commission, I have filed a maintainability application. But without hearing my maintainability application, my lord, the learned commission is passing orders for compliance of the order passed. But kindly takes the impugned order dated June 2, my lord. But page 19 of the revision application, my lord.
Page 19.
19.
Yes.
But kindly seize the order. But there is no reason for which I have been directed to be personally present. But I am a stockbroker. I am a facilitator, my lord. I have filed an application challenging the maintainability, my lord. That is.
Where is that?
That is at page 55, my lord. And the fact, my lord, that I have filed is at page 112, my lord. It has been filed online after the removal of the defects, my lord. It has to be filed physically. Page 55, my lord, is the maintainability application.
No date has been fixed for the hearing.
No, my lord, what has happened, my lord, kindly takes page 112 once.
112.
Yes. But kindly sees the first column, my lord. Keka Shaha, Mobina Ali, my lord, is the advocate on record on the law before the commission, my lord. It has been filed on 12th of May 2025. But since then, it is pending for scrutiny of defects. But unless and until the defects are mentioned and I get a chance to cure them, I cannot file it physically. But this fact was brought before the learned commission on 2nd of June.
Show me that it was.
That has, my lord, only sees what the commission has done is commission has recorded my for adjournment.
Yes, but you have not made that submission. That what is.
My lord, that has not been recorded, my lord. My prayer for adjournment was only on that ground.
Sorry, if that is not recorded, you have to approach the commission and say that by filing an application.
But my lord, the difficulty is, my lord, the commission is proceeding with the execution without going into this maintainability.
I give you liberty, you file an application.
But that has also been filed.
Stating that you are making this submission, it was not recorded. That cannot be done from here.
No, but the maintainability application is already on record, my lord.
Unless the defects are cured.
Yes, my lord.
How can it be taken
the difficulty is the defects have to be pointed out by the concerned registry.
So you file an application with regard to that.
But will kindly give me that liberty, my lord. The next date is on Monday, my lord. Will kindly give me that liberty.
Yes.
But and only one more indulgence, my lord.
No, objecting that the maintainability under revisional application before this honorable court, there is a forum of state.
Yes, my lord, there are judgments to that effect, my lord. I can.
Commission, there's a provision of appeal, but it's the only thing that he has filed an application that is not being taken up.
My lord.
What the appellate forum will do that?
My lord, kindly
nothing
see,
on merits. Nothing on merits. Only I'm giving them liberty to file an application for curing that defect.
My lord, only challenge in this revisional application the order dated.
No, I'm not interfering with that order.
But only makes
Not
it,
interfering
but
with
only
the matter. I will record his submission that he has filed an application for maintenance and
liberty
it
may
is
be
not being taken up for hearing. I will be giving him
grateful.
liberty to
Grateful.
file an appropriate application before the learned.
Grateful. My lord, and only one
Giving him immediate.
Your lordships interfering in revisional jurisdiction, my lord. There is a judgment of the Supreme Court, the revisional application does not lie
I'm also carrying 2-3 judgments, but of the Supreme Court
against
itself can be
the
done.
order passed by the district forum.
What is the order passed by the district? I am not entertaining, I am not setting aside, I am not entertaining anything. Those orders are says on merits that cannot be interfered with. I am not interfering with any of the orders. Only he says that he has filed an application for maintainability, maintainability, raising an objection as to the maintainability which is not been fixed for hearing. Is it also an appellable order? Show me that it is an appellable order. Show me that.
But only, and
Then-
madam, one more thing, madam, my lord, kindly dispense with the personal appearance of the judge.
No, no, no.
Number 6.
I
That
will
is
read
not, my lord.
Then you file an appeal.
No, my lord, then my lord, that passes
Then
that
you
order.
file an appeal.
My lord, whatever your
I
lord,
will not dispense with anything.
then my lord, it
Uh,
passes that. Give me that liberty, my lord, to file that application.
This application under Article 227 of the Constitution of India is at the instance of the opposite party number 6. Fourteen same.
Yes, my lord, 15, there is a difficulty, my lord, the 15, my lord, I had,
14 আর 15 শুধু ওই নাম্বারটা দেখে নেবেন।
no, my lord, 13 and 14 is same.
13 and, oh, sorry, 13
Yes,
and
my lord,
14 same.
15, what is the problem, my lord? The postal endorsement has come back with the opposite party being deceased.
Then you have to take steps.
But their execution, they possibly have to take steps. Before
No,
the loan,
no.
no steps have been taken, my lord. The
Sir,
proceedings.
here, that is a different thing altogether. If you want to proceed with the civil division application, you have to take steps here. Because
Madam,
carrying of
we-
proceeding lies with you. With regard to item number 15,
15, my
লিখে দিন,
lord.
the learned advocate appearing for the petitioner submits that the registered envelope addressed to
My lord, the
the-
opposite party, my lord.
opposite party number,
One, my lord. The main complainant, my lord, before the
opposite party number 1 returned with the endorsement
dead, my lord. Deceased.
disease, double inverted comma, the disease. Full stop. Petitioner will be at liberty to take steps. Full stop. Let the matter go out of the list for the present with liberty to the petitioner to mention
May be granted to file Wakalatnama within a day.
in 13 and 14.
But and 16
13,
is
14 and 16.
16 is similar, my lord.
16 is same.
Same, my lord.
16 to same order. 13, 14, 16
Deeply obliged.
Item number 17. 13, 14, 16. Yes.
Lordship, may I please your lordship?
Yes.
Lordship, on the case number will be deferred.
হ্যাঁ শুধু ওটা দেখে নেবেন
Lordship, may I refresh your lordship's mind on 24th of this month, your lordship, last month, your lordship is pleased to take up the matter. Lordship may recall my order 7 rule 11 application was dismissed when there is lack of territorial jurisdiction on the part of the learned court below. If your lordship kindly come to the plaint, which would appear at page number 10 of your lordship's brief. CJJ Infra Projects, has your lordship got it? CJJ Infra Projects Partnership Firm, page number 10, annexure P1, lordship.
Yes.
Lordship, kindly come to the cause title. CJJ Infra Projects Partnership Firm having its office at Jhankarmore, Bardwan Road, Shiliguri, pin code such and such. Admittedly, this is outside territorial jurisdiction of the learned court below. That is, and kindly come to the particulars of the defendant. Indian Bank through its manager having its office at 86/1 BB Ganguly Street, Kolkata 12. In my respectful submission, there is no branch even of the Indian Bank at the particular premises. Why I am saying so? Lordship, kindly allow me to file the supplementary affidavit. After having the ex parte ad interim order of injunction, the learned advocate appearing for the plaintiff in the court below had served gist of the order to this particular address, that is 86/1 BB Ganguly Street, Kolkata 12. Kindly have a look of the sole annexure in the supplementary affidavit, state of dispatch of the registered speed post receipt. Kindly come to page number 5. Middle portion, 8/11/2024, item return addressee cannot be located. 8/11/2024 at page number 5, track report. And thereafter, on 9/11/2024, item delivered to the sender.
It returned back.
Returned back. Because admittedly, there is no branch even in the particular premises. Lordship, kindly come to my order 7 rule 11 application, which would appear at page number 82 of your lordship's brief.
Yes.
Lordship, kindly turn over few pages, and the relevant paragraph is paragraph number 10 at page number 84. That upon, has your lordship got it?
Yes.
That upon bare perusal of the cause title of the plaintiff, it would be evident the address of the plaintiff is within the territorial jurisdiction of Bardwan Road, Shiliguri, pin code such and such, and on scrutiny of the sanction letter as annexure A herein, it would reveal that the relevant branch of the defendant bank is located in Shiliguri, also outside the territorial jurisdiction of this learned court. In order to invoke the territorial jurisdiction of this learned court, 86/1 BB Ganguly Street, Kolkata 12 of the defendant bank was mentioned in the cause title of the plaintiff, from where neither any loan document was executed nor the loan account of the plaintiff is maintained. From a cursory glance of the statement of account as annexed in annexure B here, in such aspect is unquestionably demonstrated. If your lordship kindly come to the statement of account, which would appear at page number 109 of your lordship's brief.
Was the statement of accounts part of the plaint? Part of the plaint?
No, part of my sections order 7 rule 11.
Can it be looked into, sir, in order 7 rule 11? What is the law?
Yes, lordship. I'm grateful, lordship. Lordship, may I read? Lordship, another very pertinent aspect, your Lordship, kindly come to page number 84 of my application. Para 11.
Yes.
That the defendant contends that section 17(1) of the Act provides that. Lordship, kindly come to same page, paragraph number 9. That assailing the recovery measures of the bank, the plaintiff filed an application. Plaintiff means the opposite party herein. Under order 7, under section 17 of the Act of 2002 in DRT Shiliguri, being SA number 35 of 2021, and the same remains pending for adjudication. Copy of relevant orders are also enclosed.
What is the prayer in the plaint?
If your Lordship kindly come to page number 18.
What is the dispute in this suit?
Lordship, they have sought for declaration and permanent injunction of a mortgage property, which is the subject matter in the surface application, pending in the Debts Recovery Tribunal at Shiliguri.
After Yes. Yes. Not today. Next.
Item number 19.
19, my lord, I am for the prisoner.
Yes.
Eternal revocate is on time, my lord.
Yes, yes.
My lord, I'm for the petitioner, Your Lordship.
Yes, yes.
Lordship, order under challenge in this revisional application is an order dated 29/11/2023, passed by the Lordship trial court below, in an application filed by the OP number 2 under Order 1, Rule 10, Your Lordship. Your Lordship would find that order after page number, Your Lordship, page number 52, Your Lordship. Lordship, here, brief facts are, Your Lordship, both the petitioners as well as the OP number 2 are the owners of joint undivided dwelling house, Your Lordship. Firstly, a suit for declaration and permanent injunction was filed by the petitioners. Order 31, Rule 1 application was made. That was rejected, Your Lordship. No injunction was granted. The prayer of the petitioners in the suit is that the learned court may kindly be pleased to declare that the plaintiffs, petitioners herein, they are the owners of half of the shares of the dwelling house, Your Lordship. Now, suit is pending. During the pendency of the suit, what the OP number 2 has done is that she has transferred her share in favor of OP number 2, who is a stranger to the plaintiffs, Your Lordship. He is a stranger to the dwelling house, Your Lordship. OP number 2. Now, after the transfer was made, she made that application under Order 1, Rule 10. That order is under challenge in this revisional application. Your Lordship, the OP number 2, after the transfer was effected in his favor, she has taken possession of the share that was transferred in his favor, Your Lordship.
That is a different thing altogether. Now the purchaser of a share in the property has filed an application for being added. That was allowed,
Yes.
rightly allowed.
That was allowed.
That has to be allowed.
But Lordship, in terms of Section 44 of Transfer of Property Act, stranger cannot take possession of
Stranger,
at this stage.
whether he can take possession or not, that is a different thing that will be decided. So a party addition has to be made. Ashun, this application under Article 227.
Moreover, the OP number 2 should have filed a partition suit, Your Lordship. Instead of being added in the suit, he should have preferred a partition suit, Your Lordship.
Yes, this application under Article 227 of the Constitution of India. The defendant has transferred.
Yes, dependent means OP number 1, Your Lordship.
Yes, this application under Article 227 of the Constitution of India is, where is your plaint?
Plaint, Your Lordship, would find at page number, page 18, Your Annexure P1, page 18. Annexure P1, Your Lordship. Page 16, it starts from page 16. I apologize, Your Lordship.
And where is the application for addition of party?
Lordship, Your Lordship would find it. Lordship got that order impugned, Your Lordship. Kindly turn it over after the second page of the order impugned.
Oh, yes, yes. Certified copy.
Lordship.
Certified copy of the application you have annexed.
Yes, Your Lordship.
All right.
And there, interestingly, Your Lordship, on the second page at the first paragraph bottom, the OP number 2 himself has admitted that he has taken possession.
This application under Article 227 of the Constitution of India is at the instance of the plaintiffs,
Your Lordship.
And is directed against an order dated November 29, 2023, passed by the learned Civil Judge, Junior Division, First Court at Kontai District, Purva Medinipur, in title suit number 156 of 2022. First, by the order impugned, the application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure. You have added that party who has been Suranjan Das, opposite party number 2.
Yes, yes, your lordship.
By the order impugned, the application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure filed by the opposite party number 2 herein stood allowed. First of the learned advocate appearing for the petitioner submits that the suit property is an undivided property belonging to is an undivided
Dwelling house, your lordship.
Is an undivided dwelling house of the of a joint family.
Yes, your lordship.
He further submits that the opposite party number 1 could not have transferred the portion of such property to the opposite party number 2. First of paragraph, the petitioners herein filed a suit for declaration of
Prayer at page 23, your lordship, page 23, 24. Suit for declaration and permanent injunction.
Declaration that the plaintiffs are the co-sharers having half share in the scheduled property, and for permanent injunction restraining the defendant / opposite party number 1 from transferring, alienating, and or dispossessing the plaintiffs from the peaceful enjoyment of the scheduled property or any portion thereof. First up, paragraph. During the pendency of the suit, the opposite party number 1 transferred his right, transferred his or her.
Her, your lordship, her.
Transferred her right, title, and interest in favor of the opposite party number 2. First up, the opposite party number 2 thereafter filed the application for being added as a party defendant in such a suit. First up, paragraph.
Lordship, the OP number 2 is a stranger to my family, your lordship.
The learned advocate appearing for the petitioner submits that the opposite party number 2 is a stranger purchaser, and therefore he should not be added as a party defendant in the said suit. First up, it is well settled that in case of assignment, creation, or devolution of any interest during the pendency of the suit, the person against whom such interest has come or devolved is a necessary party in such suit. First up, for such reason, this court is of the considered view that the learned trial judge was right in allowing the prayer of the opposite party number 2 for being added as a party defendant in such suit. First up, the order impugned does not suffer from any infirmity warranting interference under Article 227 of the Constitution of India. First up, accordingly, CO number such and such stands.
Lordship, one more indulgence, your lordship. In the event the petitioners move any application with regard to taking possession by the OP number 2, in that case, that may kindly be directed to be considered by the learned court in accordance with law. Kindly at least grant me this, your lordship.
Pending.
Yes, your lordship. Suit is pending.
আচ্ছা can one টাতে না একদম উপরে order করে দিন.
Can is for expeditious disposal, your lordship.
On of 2025, this is an application for expeditious hearing of CO 541 of 2024. First up, the said application stands allowed and the civil revision application is being taken up for immediate consideration.
Lordship, may I repeat, your lordship, in the event any application is moved by the petitioners.
That application If it is,
Lordship, the learned court may kindly be directed to consider it in accordance with law. That much would be sufficient, your Lordship.
which are filed will be considered in accordance with law. Yes, next.
And Lordship, moreover, if the suit can be disposed of as early as possible, expeditious disposal.
Not
your
now,
Lordship.
not now. Yes, next. Number 20.
The petitioner before your lordship is father, husband, who in pending divorce application filed at the behest of wife has filed an application under section 26 of Hindu Marriage Act and sought thereby seeking custody of the children or interim visit. Now, my lord, on 7/2/2023,
There is no caveat.
no, my lord, caveat didn't.
There was no direction for prior service.
No, my lord.
Yes. What is the order and the challenge?
My lord, order and the challenge, your lordship will be finding. If it is certified copy, then your lordship there will be no pagination. After
No. Give me the order. Which is the order?
My lord, 2/12/2023.
2nd December
2nd
2023.
December 23.
Yes.
Now, this was disposed of. My lord, may I permitted to read, my lord. Today is fixed for passing order in respect of petitions dated such and such. Finally, both parties have filed hajiras and parties are present before this court personally. In terms of order number 13 dated 20/11/2023, petitioner had produced the minor children before this court. I have talked with the minor children of the parties, namely Srihit Sinha, aged about 12 years, and Srestha Sinha, aged about 15 years. In absence of their parents as well as in presence of their parents, both children unanimously in clear words stated that they are not willing to stay with their father and also they are not intended to meet him in any manner. Now, this court is under duty to dispose of the application of husband responded to by filing an application on 7/2/2023 under section 26 of Hindu Marriage Act, read with section 6 and such prayed for custody of children as well as pending hearing and final disposal of the suit. Visiting right to the children on a daily week basis on the grounds stated in the said petition. It has already been noted by this court in its order dated 12/11/2023 that welfare of the children is paramount importance of this court for the purpose of giving custody of the children to the parents who are in tussle with each other to get custody of the children. In this case, both the children are not of tender age, rather they have grown up sufficiently to express their willingness and view regarding conduct of their parents towards them. Both the children in absence and presence of their parents have uttered before me that they are not willing at all to meet their father in any manner and are not willing to live with the father. Under the circumstances, I think it will not be prudent act to allow application filed by the respondent husband, where inter alia has prayed for permanent custody of the children. So, keeping in mind observation made by this court on this date after having talked with the children of the parties, and also in view of the discussion made by this court in passing order at 20/11/23, it appears that the instant application is devoid of merits and is liable to be rejected. Now, that the application filed by the husband such and such is considered rejected. Interim order passed in connection with the above application 7/2/23 stand vacated. This I am harping upon. The order.
What is the age of the children?
That time it was aged about 12 and 15 years.
Now
1 year is also 2 years is also lapsed. One has become major, and 12 years old child is still minor. But only thing is that the day when she was produced, the children were produced. They were not permitted to have some time with us so that I can have my motion with
Sir,
us.
what can be done?
There had been an interim order. Kindly see once interim order 7.
One is major that no
this
direction
time
can
is
be
major.
passed. So I can direct the expeditious hearing of
Major
the
means-
suit,
means,
nothing.
my lord,
Because both
17.
the children have expressed that they are not willing to meet you. What can
17
be done,
years,
sir?
not,
Sir, if the children are not willing, what can be done?
prior to that, if they could have passed some time with me because they are kept separated from
Cannot
me
be
for a
forced,
comfortable.
sir. Might be the relationship is such that the children do not want. What can be done?
Me being father, at least have some visitation right to meet my
That
children.
is for other things you have to.
Because they are kept in such a situation that the
So this is
mind of them have been manipulated for a long period.
Sir, this is an appellable order. That is why it struck me. It's an order passed under section 26, not an interim order. It's a final order. It's an appellable order under section 28. And you have kept this matter pending from 2023. You are not checking up prior to filing. And it's a final order where the interim order was vacated.
The main petition was ultimately vacated.
So, you want to prefer an appeal, or I will direct the matrimonial suit to be disposed of expeditious.
My lord, if there could be a mediation, my lord, it will be solved because
Mediation failed, I think.
once failed, if at the behest of your lordship,
So,
they sit together.
they can approach before the Planet trial judge.
No,
for
because
same
situation is
reduction.
that, my lord, I am paying them,
Are you paying alimony?
paying, my lord, at
How
least
much alimony you are paying?
70,000 I paid, she returned back entire amount, some amount she refunded back, and thereafter, my lord, I am unable to meet my children. They are becoming major. I am unable to have access to them. Now she is also not residing with me. Section 9 order was passed. Despite that, she failed to restitute the conjugal rights. Now situation is like that, my lord. Just I am fighting in the courts, having no access to my wife and children also. And there had been a contempt order, contempt application against her for not following the orders of the court. Time and again, she was directed to produce the children. She didn't produce. Ultimately, when I filed contempt application, then she produced. And the moment when she produced, the children were produced in city center, my lord, there a huge drama was occurred. I had to leave without cutting the cake of the son of my son on his birthday. Too much hostile situations have been created so that I can not meet my their own children.
What do you want now?
But
Do you
if,
want to prefer an appeal or you want expeditious disposal of the suit? What do you want?
I will prefer appeal because I want only that.
Ashun,
Deep level.
yes, Mr. Banerjee.
Order already passed, my lord. My lord, other side is not here, my lord.
Then you have not notified them also. What can be done? You have mentioned. Not today.
Matter appeared as original form. Item number 22. I shall mention this matter on next month. Wednesday, my lord. Again, my lord, I mentioned this matter, my lord. I shall after notice. এটা কি আপনার ইয়েতে ওখানে চলে আসবে তো? হ্যাঁ?
Not today. Next.
Number 23.
23, my lord, I beg to appear.
22, my lord.
22, you have not responded.
No, that was, I thought 21 he was submitting. 22.
22, yes.
My lord, 22, my lord, I am for the respondent. My lord, I had specifically, my lord, ensured the matter, my lord, be heard, and I mentioned several times. The arbitration has been stayed, my lord, because
Now
of
what
the
can be done
pendency.
today? Today, in
No.
the presence of the petitioner, nothing can be done.
All I'm saying is, my lord, let it be taken up any day convenient, your
I
lord.
cannot fix today. Today, I have not fixed any matter. Today was a special day for which these matters will be taken up. Fixing the problem because other matters are fixed on different dates. Yes, next.
Item number 23.
My lord, 23, my lord, I beg to appear on behalf of the petitioner, my lord. My lord, the petitioner.
I will remember that. Then I will not give any liberty to this. I will also stop you from mentioning. If you say that without liberty, you are not
Going on. For 1 year, my arbitration has stopped. And the petitioner is intentionally not here, my lord, because they are enjoying this situation. The arbitrator, my lord, has said that
You
because
have taken a resolution, what can be done? You have taken a resolution today.
know whether we have adopted. And the other side, my lord, is Mr. Shakko Sen, Mr. Aniruddha Mitro. I don't know why they are not come. Very well, I'll try.
Hold of them, bring them.
Very well, my lord, I'll mention, my lord.
Yes, yes, Mr. De.
My lord, the petitioner 6 for expeditious hearing of my lord, application or under order 21 rule 101, my lord. And my lord, the miscase of police help, my lord. My lord, the decree was passed in the year 2016, eviction decree.
But the decree holder or the
I am the decree holder, my lord. Decree holder. My lord,
miscase number 2 of 2017 is order 21 rule 101.
no, my lord, miscase number 38 of 2016 is application under order 21 rule 101, and miscase 2 is for the police help, my lord. That is arising out
38 of 2016 is
yes,
for
yes.
Ashwin,
My lord,
this-
examination completed, hearing on the part of the decree holder completed, but last was it was heard on 5th of July, next date not given. It is on the
of July of 2025.
5, my lord.
So it's at the evidence stage.
Evidence completed, my lord. Argument on the part of the decree holder concluded.
All right. This application under
My
article
lord, may I just indicate two orders, my lord? Kindly come to page number 48 once. 48.
Yes, 48.
48 initially the order for expeditious hearing was passed on 21st November 2017, passed by His Lordship Justice Tandon, my lord. Here no time limit has been given. The next page, page number 50.
Yes.
Page number 50, 6 months time was given. My lord, second paragraph, last two line. 17 July 2019. And subsequently, my lord, on 5th September 2023, page number 51. The 3 months time is given. My lord, till my lord, it is going on.
This application under Article 227 of the Constitution of India is at the instance of the decree holder praying for a direction upon the learned.
My lord, it is pending before
Learned Civil Judge Junior
Learned Civil Judge Junior Division, Second Court, Shialda.
to dispose of the miscellaneous case number 38 of 2016 and miscase number 2 of 2017 expeditiously. First up, Mr. De, learned advocate appearing for the petitioner submits that miscase number 38 of 2016 was filed by the opposite party number.
All opposite parties, my lord.
By the opposite parties under the provisions of Order 21, Rule 97, 201, TO2, 101 of the Code of Civil Procedure. First, he further submits that in spite of repeated directions being passed by this Honorable Court, no further progress in the hearing of such application has been made. First up, he however submits that the miscellaneous case number 38 of 2016 is at the argument stage. First up paragraph, in view of the order sought at Korodhaman, in the light of the submissions made by the learned advocate for the petitioner and taking note of the fact that on repeated occasions, directions were passed upon the learned executing court to dispose of the miscellaneous case number 38 of 2016, CO number such, the executing, the learned civil judge, Junior Division, Second Court at Shialda is requested to dispose of the miscellaneous case number 38 of 2016 as expeditiously as possible, but preferably within a period of 3 months from the next date fixed. First up, the learned executing court is requested to proceed with the miscellaneous case number 2 of 2017 and make an endeavor to dispose of the same as well as the execution case as expeditiously as possible without granting any unnecessary adjournments to either of the parties. With the above observations and directions, CO number such and such stands disposed of. আচ্ছা মিস কেস যেটা 38 of 2016 তে বললাম না expeditiously without granting any unnecessary adjournments আছে কিনা দেখবেন তাহলে ওটা ঢুকিয়ে দেন. Yes, next.
Grateful, Your Lordship.
Oblige. Oblige.
Item number 24.
So, my lord, this is an application for expeditious hearing, my lord, of title suit number 572 of 2019, pending before learned 6th Civil Judge Junior Division. My lord, since 2019 till today, issues are not framed, my lord. And my lord, the defendant has filed one application for repairing, and that has not yet been disposed of, and court is giving long dates, my lord, 4 or 5 months dates, my lord. That is why I have come here before your lordship for expeditious hearing.
No counterclaim has been filed.
No count.
The repairing application is pending.
Yes. And on the last occasion, my lord, 500 rupees cost has been imposed, my lord, upon the
Counterclaim has been filed.
one written statement has been filed, my lord.
Written statement with counterclaim.
Counterclaim, yes.
So what are the applications pending? The
My
repairing application
Repairing application.
and issues have not been framed.
Have not been framed.
First up, Ashun, this application under Article 227 of the Constitution of
Number 25.
My lord, item number 25, I am for the petitioner, my lord.
Yes.
There was an impugn order passed by the learned district judge, my lord, Postim Bardhaman, arising out of a misappeal on 07 of 2020, my lord, under section 9 of the Public Premises Unauthorized Occupation Act of 1971 on 2/3/2023, my lord. The learned district judge has affirmed the order dated 27/2/2020, my lord, passed by the estate officer, whereas the husband of the petitioner, Sri Ranjan De, and the other persons were evicted from that quarter, my lord, belonging to sale. That is on page number 49, my lord. And the husband of the petitioner has abandoned her, and she has filed various cases against him, such as the DV Act, Miss Case number 218 of 2000.
Now the wife is in occupation.
Yes, my lord.
Occupation, my lord. I am appealing on behalf of the respondent. I am led by Mr. Taposh Kumar Banerjee.
Husband has abandoned her, my lord, and she has nowhere to go. That
My
is
lord,
the-
You are the husband.
Yes,
Yes,
my
my-
lord.
You are the wife of the husband.
Yes, my lord.
What is?
We are the wife.
Water was allotted, my lord, my senior.
Yes.
Lordship, kindly see the order itself.
Yes.
Only order, my lord. There is my lord, the person concerned has already been retired. They
Yes.
may have a matrimonial dispute, does not mean, my lord, my house should be occupied. He can make an arrangement whatever he can like. The courts has given an order ki residential.
Want some time, I can request them to give some time to vacate. You cannot stay there for long.
My lord, we have to
No,
take
already
instructions. My lord.
2018, the husband was retired.
It was since 2016 going on. This is 2025.
Till now you have not got.
I'm very sorry to say anything, my lord.
If you want some time, I can give you time.
My lord, I don't.
Because you do not have any right
Lord.
to, you do not have any right to occupy.
Then I need some instructions, my lord. I'll come back again.
Then I will decide it, come at 2. I will decide this matter.
Surely.
No need to take instruction. Yes, Mr. Banerjee, please join at 2 p.m. I will.
Lordship.
My lord, can I take instructions in the meantime, my lord?
Take telephonic instructions, come back at 2. If you can file an undertaking that will vacate, I can request them to give some time.
But not only that, my lord, they have to pay unauthorized occupation charges also, my lord, for the long 5 years.
Banerjee, you recover that. First, get the property if they want to vacate. Because till now, neither you have got property, neither you have got anything.
Yes, my lord, the appellate authority has also held the same
Let us
thing.
see whether they are willing to give you possession.
Yes, my lord. Yes. Let them give an undertaking, my lord, that will be.
Yes.
Lordship.
I'm obliged.
Continue, matter.
Matter number 25.
Yes.
Will it be my lord's pleasure to take up any matter from the monthly list? I'm not, the other side is not on cave yet. Any time my lord deems fit, my lord.
You have not mentioned it earlier. No. Cannot be done because it cannot be taken out now. Yes.
We have tried to contact the advocate on record, but we could not reach the client.
All right, you can proceed with the matter on merit. Yes.
That is my only submission, Lordship. That is my only submission, Your Lordship.
What is your only submission?
That she has nowhere to stay, my Lordship.
That is your only submission.
Yes.
Yes, Mr. Banerjee.
Lordship, kindly see the order, my lord, appellate authority's order from page 1. What was her grievance?
Yes.
There was no such grievance, my lord. She admittedly said that she is a wife of certain person who has already been retired. He has taken voluntary retirement and issued to the authority for surrendering the house. The house was not surrendered since 2016.
Yes.
And proceeding has been started in 2018. The order has been passed, and thereafter, my lord, kindly see what the pro forma respondent has said. She has also appeared before the state officer. She appeared in the state. There is no violation of any principle of natural justice or anything. And thereafter, the decision taken by the authority, by the appellate authority, if your lordship kindly turn to page 4. It is very small writing, my lord, of the type of.
Yes.
In appeal, pro forma respondent is the husband.
All right. Yes. Yes. Yes, Mr. Banerjee.
Lordship, kindly come to page 4 of the order.
Yes.
It is not disputed that the pro forma respondent took voluntary retirement from the service of the respondent 2 in 2016. Respondent 2 stated in the application for vacating the stay and that such voluntary retirement was accepted with effect from 30th/5/2016. Peruse the records of the state officer is Xerox certified copy of the order dated 4/10/2016 in Miss case number 2018 of 2016 in place is placed on such record. Such Xerox certified copy of under order regards that an order of interim maintenance is at the rate of rupees 4,000 per month, which per month was passed in favor of the appellant by the pro forma respondent. Pro forma respondent husband was directed to give residential right to his quarter to the petitioner appellant in default directed to provide a sum of rupees 3,000 per month in lieu of expenses towards the residence.
Yes.
That is the liability of the husband and husband in lieu of the residence. It was also not out of place that the pro forma respondent took voluntary retirement from the service as way back in 2016. Therefore, by no such stretch of imagination, it can be stated that the pro forma respondent has any right to occupy the official quarter given in lieu of his service. When the pro forma respondent ceased to have any right to occupy the quarter, the appellant who extracted the right through pro forma respondent ceases automatically. Appellant cannot claim right to occupy the residential quarter, which should be available to other official in service. The contention of the appellant that if the quarter is handed over, then the pro forma respondent will flee with the retirement benefit is also without any legal basis. It is not out of place to mention that the appellant has already got order of maintenance from the appropriate competent court. thus, it is also clear that the appellant is the unauthorized occupant of the society. 4 and 5, my lord. She is further stated that the principal, my lord, this is the, she has no legal right to stay there, my lord, and she has also not challenged. She is a wife of a person who has already wanted to surrender the house because he already retired in 2016.
That is the order of the estate officer.
My lord, that is
47,
Lordship, page 49.
7 to 50. 49, 50 is a typo.
49 and 50.
Yes.
It seems, my lord, this is a virtually mercy petition before a lordship, my lord. What I can say more than that, my lord. She has no legal right in section 5. She has not challenged even.
Yes.
And 3,000 in maintenance, in lieu of residence, she has been asked by the husband to make payment. If he is not paying, my lord, what the employer can do?
Yes. Madam, anything more?
Yeah, Lordship.
This application under Article 227 of the Constitution of India is at the instance of the appellant in miscellaneous appeal number 7 of 2020 and is directed against an judgment and order dated 2nd of March 2023 passed by the learned district judge Paschim Bardhaman. First up. By the order.
One thing, my lord, there is another judgment, if your lordship so desire, of this Calcutta High Court.
Yes.
Absolutely on pat of the point, my lord. If your lordship kindly, my lord.
For what proposition?
This is the purpose, my lord, that she has no right and she has to be evicted from there.
2015 SCC online Calcutta 10440.
Yes.
This is also Calcutta Law Journal. It is also reported, my lord. Paragraph 4, 6 and 7.
Paragraph 4, 6 and 7.
4 is the relevant portion, my lord.
Judgment for Macquarie.
Here also matrimonial dispute.
Yes. Judgment for Macquarie.
If spouse right to enjoy the occupation of an official accommodation quarter, or even calling it his or her matrimonial home, coexists with the right of the allottee spouse to enjoy the occupation of such accommodation quarter, but cannot travel beyond the official accommodation, cannot travel beyond the allottee spouse entitlement or right of enjoyment.
Yes, sir.
Manoj, this is the crux of the matter. This is the paragraph 4, my lord. This is the.
Seen that.
Lordship. I'm sorry, my lord. I interrupted your lordship while dictating, my lord. I'm very sorry, my lord. Should not.
Up to that is the decision of this court. First up, by the order impugned, by the judgment and order impugned, the order dated February 27, 2020, passed by the estate officer in case number estate/Q dash capital B /75 /2020 DSP stood affirmed. Paragraph. The learned advocate appearing for the petitioner submits that the petitioner is the wife of the opposite party number 3 herein. She submits that the opposite that there are matrimonial that there is a matrimonial dispute between the petitioner and the opposite party number 3. First up, the petitioner and the opposite party number 3 started residing in the quarter allotted by the opposite party number 2 in favor of the opposite party number 3 and the opposite party number 3 left the petitioner in the said quarter and is residing elsewhere. She submits that the petitioner does not have any other alternative accommodation for her to reside. First up paragraph, Mr. Banerjee learned advocate appears for the opposite party number 2. First up, he submits that the opposite party number 3 was allotted a quarter by the opposite party number 2 as a condition of his service. First up, he further submits that the opposite party number 3 has have tendered his resignation. Tendered his resignation under
retirement, voluntary retirement.
the petitioner, the opposite party number 3, retired under the voluntary retirement scheme, and and thereafter has left the quarter. First up, he submits that the estate officer passed an order of eviction.
Thereafter, he surrenders the quarter. Surrenders
that the opposite party number 3 also surrendered the quarter by a letter.
By writing, yes, ma'am. By writing.
Surrendered the quarter by issuing a letter to the opposite party number 2. First up, Mr. Banerjee places reliance upon Mr. Banerjee further submits that the estate officer passed an order of eviction which has been affirmed by the learned district judge in an appeal under section 9 of the Public Premises within bracket Eviction of Unauthorized Occupants Act. What is the year?
1971.
1971. First up, Mr. Banerjee places reliance upon a decision of a coordinate bench in the case of Sheikh Abdul Mutle versus Holdia Dock Complex and others, reported at AIR 2015 Cal 205 in support of his contention that the spouse right, spouse apostrophe s, right to enjoy occupation of an official accommodation slash quarter cannot travel beyond the allottee's entitlement or right to enjoy occupation of the official accommodation slash quarter. First a paragraph. Heard the learned advocates for the parties and peruse the materials placed. First up, after record reveals that the Mr. Banerjee, before the estate officer, who contested?
My lord, the respondent were 2 and this rich petitioner, this petitioner also.
Both
yes.
of them contested.
Yes, yes, she appeared there.
And before in the appeal also both contested.
Yes, my lord.
Record reveals that the petitioner herein as well as the opposite party number 3 contested the proceeding before the estate officer. First up, আচ্ছা এটা তার আগে না এটা একটু লিখে দিন. Record reveals that the notice under section 4 within bracket 1 of the Public Premises within bracket eviction of unauthorized occupants bracket closed act 1971 was issued to the opposite party number 3 herein, directing him to show cause as to why the eviction order should not be passed against him. Full stop. The estate officer thereafter it further appears from the record that the petitioner herein as well as the opposite party number 3 contested the proceeding before the estate officer. Full stop. The estate officer took note of the order passed by the judicial magistrate Durgapur in Miss Case number 218 of 2016, whereby the opposite party number 3 was directed to give directed to pay an amount on account of interim maintenance of rupees 4,000 per month, and the opposite party number 3 was further directed to pay a sum of rupees 3,000 per month towards the cost of residence. Full stop. The estate officer, after noting that the opposite party number 3 herein had voluntarily retired from service with effect from June 30, 2016, held that the opposite party number 3 does not have any right to occupy the official quarter given to him in lieu of his service after his voluntary retirement from service. First up, the petitioner challenged the order passed by the estate officer by preferring an appeal being Miss Appeal number 7 of 2020. First up, the learned district judge, after considering the materials on record, held that when the opposite party number 3 has ceased to have any right to occupy the quarter after his voluntary retirement, the petitioner herein cannot claim any right to occupy the residential quarter which is to be made available to other officials in service. The learned district judge further noted that the petitioner as well as the pro forma opposite party number 3 herein got sufficient opportunity to contest the proceeding before the estate officer. Full stop. It appears, record reveals that the petitioner as well as the opposite party number 3 were also were also given sufficient opportunity to represent their case before the learned district judge. First up, thus, there has been no violation of the principles of natural justice. First up, the issue that arises for consideration is whether a wife has a right to enjoy occupation of an official accommodation / quarter allotted to her husband as a condition of such service. Such issue is no longer res integra. Stop. A coordinate bench in Sheikh Abdul Matleb Supra is no longer res integra. Correct. Full stop or likun. A more or less identical issue cropped up in Sheikh Abdul Mutleb within bracket Supra. Wherein the husband and the wife used to reside in the official accommodation or quarter allotted to the husband. Full stop. Thereafter, the husband voluntarily retired from such service. Full stop. The coordinate bench held that a spouse right to enjoy occupation of an official accommodation / quarter cannot travel beyond the allottee spouse's apostrophe's entitlement or right to enjoy occupation of the official accommodation / quarter. The coordinate bench held thus বলে প্যারাগ্রাফ 4 থেকে 7 পর্যন্ত সেট আউট করে দেব set out paragraph 4 to 7 of the said decision. In view of the aforesaid discussion, this court holds that the petitioner has no legal right nor is entitled to remain in occupation of an official quarter allotted to her husband during the course of his employment when her husband has already moved out consequent upon his voluntary retirement. First up, the learned judge, the learned district judge considered the materials on record and assigned cogent reasons in support of the ultimate conclusion. First up, this court is therefore not inclined to interfere with. This court is therefore not inclined to interfere with such order in exercise of jurisdiction under Article 227 of the Constitution of India. Accordingly, CO number such and such stands dismissed. There shall be, however.
Well, Lordship, kindly consider paragraph 8. If
Yes.
your Lordship's of paragraph 8. Lordship has given it, man. In coordinate bench, man. I'm just paragraph 8. So somebody has to pay the occupational charges, my lord.
It will be open to the party number 2 herein to take appropriate steps for realization of the dues in accordance with law.
Occupational charges.
Any dues?
Lordship. I'm grateful, Lordship.
Thank
My lord,
you.
one subject to one correction.
Yes.
Of course, that is for the senior advocate, my lord.
Oh, sorry. Thanks. Mr.
This is the first time I'm appearing before your Lordship after
Sorry,
becoming.
yes, Banerjee, yes. ওটা মিস্টার ব্যানার্জি যেটা বললাম না, লার্ডের সিনিয়র অ্যাডভোকেট।
I'm obliged, my lord.
Yes.
I'm grateful, Lordship. My lord, I'm grateful.
Yes.
This is my application for expeditious hearing before the consumer forum.
Yes.
My lord, the order was passed in my favor in 9 January 2018.
Execution proceeding.
Execution proceeding, my lord. My lord, the appeal was dismissed for default in 2022. Since then, my lord, the execution proceeding is pending. My lord, my application for under section 71 as well as 72, both, my lord. My lord, last date of hearing was July 2025. Next date is on November 2025. my lord.
This application under Article 227 of the Constitution of India.
It is my application, my lord. My lord, petitioner is the my lord senior citizen.
Yes,
My lord,
what do you want?
He filed, my lord, the partition suit, my lord, in the year 2007. And my lord, 2013, my lord, preliminary degree was passed. My lord, thereafter.
Final degree proceeding is pending.
Yes, my lord.
Final degree is at what stage? Commissioner filed the report.
My lord, no. Nothing. Every day, my lord, unnecessary adjournment is given. And my lord, commissioner did not file.
An objection. Objection has been filed. No, it has been fixed for objection of the commissioner's report. This application Yes.
Leave the
একটা দিন
Item number 29.
For 29, I'm for the petitioners. There's a caveat in this matter. I'd served notice. There's a caveat in this matter. I had served notice on 7 July and I also called him. He said he would try to appear virtually, but I'm not sure whether anybody is appearing virtually or not, my lord.
What do you want?
But since there's a resolution, my lord.
Not today, next.
Grateful, lordship.
Item number 30.
Right, 30 is my application. Mr. Chatterjee is leading me in the matter, my lord. He's online. Mr. Aniruddha Chatterjee, my lord.
I'm online, but if the other side is not there, key.
Other side, not here. Not today, next. Why have we not notified the other side?
We mentioned upon notice, my lord.
Well, we have mentioned, we have done everything, but anyways.
But we have taken a resolution thereafter. Thereafter, you have taken a resolution.
We had also requested for a postponement. My lords didn't adhere to that.
Yes, next.
He had said that on Saturday, last Saturday, if that was done, would have been the best thing. But my lords have not adhered to that either. So we are in a soup.
Yes.
31, my lord, I am appearing for the petitioner, my lord.
Yes, yes.
The petitioner,
No caveat?
no caveat, my lord.
Yes, thank
The
you.
petitioner filed a title suit being TS that the principal defendant number 1 regarding execution of the sale deeds being 641 dated 22/24 and 642 dated 22/24 in favor of the principal defendant number 2 to 4 as constituted attorney of the plaintiff may kindly be declared as void, my lord, and other players, my lord. Others player, my the principal defendant restrained by an order of permanent injunction right, title, interest, and possession of the suit property covered by those deeds. And in the said suit, the petitioner filed an application under and the landed court asked the status quo by maintaining both the parties from changing the nature and character of the suit property and possession, my lord. During the pendency of the said suit, my lord, the others have purchased the property from others purchaser, my lord, and they are filing the application under order 1 party, my lord. My lord, the landed court below allowed the said addition of party, my lord, and directed to amend the cause title and serve the notice upon the respondent.
Yes.
My prayer, my lord, the lease pendants, doctrine of lease pendants, my lord. My lord, doctrine of lease pendants, my lord, during litigation should be, my lord. This is my lord.
Now they have acquired interest. So any decree passed against their predecessor in title, they will be bound by that. Their predecessor in title after transferring will not have any interest to contest. So let them contest, have a decree against them.
My lord, if one after another sell, one after another.
This application under Article 227 of the Constitution.
after another will be added as a party manner. My lord, suit will not be
Yes,
ended.
call the next matter.
Grateful, my lord.
Yes, Mr. Shah.
My lord, perhaps this can be disposed of. I'm asking for, my lord, preponement of hearing, and my lord, I'll tell your lordship.
Preponement of hearing of what?
PRAT
Mr.
matter.
Shah, other side is here.
Yes, my lord, but it
So
will.
they are not here.
I'm not asking for vacating. I come against an order of injunction. I have come against an order of injunction dated 13th March. Now, my lord, I am not saying that, my lord, your lordship vacates the injunction. Nothing.
Mr. Kormukar is here.
No, he is with-
I'm being led by Mr. Shah. I'm being led by Mr. Shah.
Led by
My lord was of the opinion to make a direction in this, pass a direction in this matter.
I'll tell your lordship, kindly see these two subsequent orders passed after, my lord, filing of this CO.
But only difficulty, Mr. Shah, is opposite parties are there. If they come and say orders have been passed against us, there is a resolution also.
Yes, I know that.
So that's the difficulty because
Then, my lord, may I come back on 5th, my lord, subject to the courts? 5th.
that
No, my lord, I don't want to put my lord, your lordship, especially in any
that's the
embarrassment.
only difficulty.
No, my lord,
because
I understand, my lord. I don't want to, my lord.
can you not ask them to join virtually? Mr.
We had done that. We had done that, but they are unwilling for obvious reasons.
No, my lord, I don't want your lordship to
Mr.
pass in
Shah,
order.
I can do one thing.
Yes, my lord.
So you want preponement. So I can give you liberty to apply for preponement there because Mr. Shah, from here preponement will be a
No, my lord,
difficulty.
your lordship, but let
I can only record your submission, give you that liberty, but I have to keep this pending.
very well. That will work. That will work. I'll be happy with that. Only one thing. My lord, kindly, my lord, permit me to, my lord, place just one order, two orders, my lord. This is, my lord, important for your lordship to see because, my lord, debt recovery appellate tribunal, my lord, is an appellate court. My lord, kindly first take the order of 8th May and then, my lord, order of 14th July. Now, my lord, on 8th May, this is subsequent to the filing of the CO.
Yes.
On 8th May, my lord, as I have to, I inform the court that against the order of injunction, I filed a CO. At that point in time, my lord, kindly see, they asked for, my lord, their own people, my lord, asked for a chance to, my lord, file opposition. Kindly, my lord, see. At
For
the
hearing of the appeal, 14th of July.
Yes, for hearing, but my lord, your lordship will see the last line of the first paragraph.
Yes.
Copy of order dated 24th April 25 passed in so and so placed on record, which shows that no interim order is in force. So his lordship, my lord, was keen to hear the order because, my lord, there is no interim order, keen to hear the matter. And, my lord, last line of this order, fix the matter for hearing on 14th July. Very well. Now, my lord, kindly take the 14th July order. Why have I come in CO? That's the problem.
So it was directed the 22nd of July for hearing of the appeal.
No, so but he says that because you filed a CO, I am not intent. Kindly see, my lord, the language.
So Mr. Shah, if you want to withdraw this,
No, my lord, I don't want to withdraw. I want, my lord, fixation, my lord, liberty to pray for preponement.
What is
And
the next date fixed?
my lord, 1st September. I am suffering an interim order. My lord, 6 crores of rupees due, my lord, as on, my lord,
Mr. Shah,
2021.
you are the best person to say whether preponement is possible there.
Yes.
I'm not saying permissible. Possible.
My lord, this is, my lord, this is, my lord, question from your lordship to me personally, yes. Most of the days, my lord, his lordship rises at 2 o'clock. This is, my lord, appellate tribunal, not the DRT. DRT, my lord, very difficult. DRT is swamped with work. Then, my lord,
So I'm recording your submission that is fixed on 1st of September. I give you liberty to apply for preponement.
yes. And, my lord, if such is made, will be considered sympathetically. That's all, my lord.
Mr. Shah
Item number 33.
Yes.
Deeply obliged, my lord. Great.
Thank you, Mr. Shah. Yes.
I am appearing for the private opposite parties.
Private opposite parties.
Yes.
Petitioner is not here, sir.
I'm for the petitioner.
Municipality is not here.
I have already your lordship, the entire case is on a single point whether the deviation made by the petitioner comes under a minor deviation or not. In the order of the municipality, it is clearly recorded that all total the deviation is around
Municipality is not here. I cannot take it up on merits. Yes, not today, next.
Your lordship, then they are enjoying the interim order. Kindly fix up a date for early hearing, your lordship. Otherwise, I will be.
Today I cannot fix it. Yes, yes.
Item number 34, fixed matter.
Yes.
My lord, I appear for the petitioner. In some bit of a predicament, Mr. Chatterjee was leading.
Mr. Chatterjee was here. Last matter he was
Mr.
here.
Chatterjee has recused himself, my lord. Some
He
conflict
has
of
recused.
some conflict of interest. So my lord,
Yes.
that is the kind of predicament we are in right now. I got informed day before yesterday, and the misdoing appears to be that of Mr. Shoroshi's Dashgupta.
All misdoings from this part.
Absolutely, without a doubt. Whenever there's a senior appearing on the other side, mother, the misdoing has to be from there.
Then, Mr. Bordon, what can be done?
Any day subject law fixes.
Today, for today,
No.
it's adjourned.
This was fixed. This, well, kindly,
Fixed
any
for-
day.
Mr. Bordon,
This matter was taken up. No. This matter was taken up on an early location, and knowing that 2nd of August would be a working day, Muller was to fix it. Now, fix it
yes,
any day.
I told you on that day,
Yes.
but fixing now is a, let me see what can be done.
What happens? So there's another proceeding pending before Justice Shorkar. Section 9. Now, that is not being taken up because of this pendency of this, Muller.
But in any event, my lord, that is there.
Not
It
in
is
any
at my
event,
request.
in
My
event.
request. At my instance.
Exactly.
This revision application is at my instance. I am ready and willing, my lord.
That was
Just
sought
gives
for
me
answer.
some time. I'll
Yes,
come back
yes.
and I'll have the matter ready. I can start off, my lord, but the stakes are pretty high. That is the reason why. If your lordship wants to hear the crux of the matter, and I can, of course, cite the judgments also, but nonetheless,
They can do everything.
I think has to be
Starting, citing judgment, complete.
absolutely great.
Then I
so it has to end.
Absolutely.
I will end.
It'll actually, in fact, my learned friend,
He starts, I end.
or else it might be the other way around, since my learned friend has taken the point of maintainability.
No, I didn't take this. I said that
But-
42.
Anyway, my lord,
An application at my instance under 42. Saying the 34 was not maintainable.
yes,
Not
very
any day subject logical. Any day.
any day, any day. In fact, that is something I will be. Well, it was a long while back, perhaps in June, early part of June, early or middle of June.
It was the 8th of July.
8th of July. Yes, my lord, 8th of July.
Everything has been stalled, Malad. Section 9, Malad, occupational charges, everything, Malad.
Occupation charges, perhaps Mr. Bordon has not been appropriately instructed, my lord.
Section 9 is for enhancement of occupational charges.
It's there. Any day, whenever your lordship pleases, my lord, we'll come back and argue at the matter.
No, নেবে না। ভদ্রলোক। জয়ন্ত ভদ্র, টাইম নেবে না।
Yeah,
Twenty-seventh. There is 2 before 7. You are right on 7 is correct, but there is 2.
27
এই গণেশ চতুর্থী ছুটি নেই তো না প্লিজ আর কত ছুটি খাবো
It's in your hand, Mr. Porto. Everything is in your hand.
any time বলো
4 p.m.
Malad, can it be 28th instead of 27th?
28th is fixed. I've checked that.
Preponement can have it preponed. I don't stand it.
No, preponement is possible. Then it
Because
must
my
be.
learned junior is in some difficulty.
No, I'm not. Then it has to be in September.
Malad, any day. Can be 1st of September, 2nd of September, any day.
September কি অবস্থা?
230 or 4?
4, no 230 business. Ashok.
4 it might not end.
Because some upgraded mentioned matters are there and other things. That is, I'm trying
I
to
appreciate.
accommodate all the.
I appreciate. I
That's the difficulty because this will, if this is taken up and continued for the whole day, other
It will
matters.
take
That's
some time.
because
Because there are judgments
you
to
can
be
continue after 4:30 also. That's
That we will do.
that.
That we will.
কবে বললাম 4 না 5 কি বললাম?
Fourth of